it just doesn't make sense. Sometimes you put in all this work and you're giving the case to the judge and you're waiting for her decision. And then you start to talk settlement. Usually settlement talks, well, they've already happened. Certainly the court requires them to happen before you even get to this point. So if you're so far apart that you can't settle the case, I don't know why anytime after the briefs have been filed, that would change. Usually something changes and the party's position changes. Like, for example, let's say the SEC didn't want to settle the case. They wanted to get case law made from this case, and they were going to move it forward all the way to the judge, no matter what.
Yeah.
But the judge just ruled against them and they have to give over these emails. That's something that's changed in the litigation, which might change their perspective and might lead to a settlement. But once the summary judgment briefs are filed, the case is all laid out for the other side to see. There's no secrets anymore. There's no more pending motions. Nothing is going to change in the litigation. Why would anyone settle at that point? That doesn't make any sense to me. Now, that being said, we had a trial last month and it literally settled. So the trial started like on a Monday morning, and the jury was brought in, and an hour into jury selection, we settled the case with the other side. Okay. It's kind of an interesting story because we were in the middle of voir dire, which means you're picking a jury. And the other side passed us a note saying, can we talk outside in the hallway or something like that? So we go outside and it literally settled with the jury waiting for us. And we were in the middle of jury selection. So it can settle at any time. But to me, if you submit your briefs and nothing else is going to change, then, why would a settlement happen at that time? Okay. So which I'm saying, I would expect if there's going to be a settlement, it would be before November 15.
Okay. And also, I think last time when we met, like you mentioned that good judges usually give hints.
The end is nigh, people. The XRP lawsuit is coming to an end.
John, obviously the case, if you look at some of the motions, is going in your favor, going in the favor of Ripple. It seems like the judge is siding with them on motions for discovery, on document requests, including Bill Hinman, that former SEC chairman's notes involving his speech that Ripple says is a big part of their case. And you've been right there all along since the beginning as amicus curiae. And now, from what we understand, they want you gone.
Scoop. In the SEC's case against Ripple, SEC lawyers have asked the judge to disqualify John Deaton as amicus curiae on grounds that he is improperly interfering in the case via social media, a charge that he denies. That was from Charles Gasparino. Jake Chervinsky on this one. The general rule in litigation is that you only file motions to exclude stuff that you think will hurt your case, since otherwise, why bother? So I take this as a sign either that John Deaton has really gotten under the SEC's skin, or he has a point to make, or both, either way. While responding to that, Moon Lambo says the SEC increasingly becomes desperate and unhinged. The nonsense they argue is epically bad. They don't believe the words they say and write. So from these recent events, we can see that the Ripple vs. SEC lawsuit is really about to come to an end. However, some important notes have gotten spectators analyzing a more than favorable end for Ripple than the SEC in this lawsuit. One of which is the one where the SEC, even though it's done a miserable job at defending its initial claims against the fintech startup, is using delay tactics to prolong expert discovery, hence summary judgment. Now it shifts its attention from its primary target after receiving several blows from both Judge Netburn and the defendant's counsel to a more insignificant entity in this lawsuit, attorney John Deaton. So what do you think about the SEC's attitude, guys? Is this lawsuit coming to an end? I very much think so. In the meantime, as always, hit that subscribe button and don't forget to turn on bell notifications.
Well, there are sure signs that the crypto winter may be thawing as prices have kind of been on a tear over the past week. Now, Bitcoin earlier today breached the $24,000 ceiling. Right now, it's just slightly below that. It's getting a 0.5% gain here. We're at 23,594. It's seen gains of about 20% over the past 7 days. Ether was higher earlier. Right now, it is slightly down 1.25%. But Ether's had even bigger gains on the week, up 44%. And take a look at XRP. Now, it too was higher earlier. It's down about 1.5% at the moment, but It has seen year to date a problem, more than 55%. But all that could change on the outcome of one highly publicized court case between the SEC and crypto company Ripple. Lawyer John Deaton is very much a part of that case. He's been there since the start, representing 68,000 retail investors that hold XRP. He joins us now with Charlie Gasparino. Charlie.
As the SEC's most senior counsel in this case had earlier agreed to the purpose of the William 2018 speech, which was intended to provide the market with clarity as affirmed by the SEC's senior trial counsel, Attorney Guerriere, before making an about-face to declare otherwise. In her own words, Attorney Pascal Guerriere, a lawyer who was involved in the most recent and first settlement to a fintech company under Gary Gensler, stated in the June 7th hearing that the purpose was to provide guidance to the market on legal issues before the SEC. And basically, Director Hinman was giving the market the views of how the SEC would treat digital assets under the securities laws. These credentials are related to a speech given by a former high-ranking SEC official in the person of Bill Hinman in 2018, when he was the then Director of Corporation Finance at the SEC and sought to provide clarity on the then-nascent cryptocurrency market. Hence, withholding such information, which could help the judge reach a much quicker decision in terms of summary judgment, has irritated not only the members of the XRP community, but Judge Sarah Netburn herself. Essentially, this isn't the first time an SEC high-ranking official would refer to the Hinman speech as providing regulatory guidance to the public. Take a look at this footage from the recent past chairman of the SEC talking about the same thing.
What falls within the ambit of a securities offer and sale is a facts and circumstances analysis, where we use a principles-based framework that has served American companies and investors well for over 80 years. Bill Hinman recently outlined the approach we take to evaluate whether a digital asset is a security, and I encourage you to take a look at Bill's speech, which is available on our website.
What has all that got to do with Ripple and XRP's growth rate? Guys, let's take a look at this tweet from Eleanor Terrett from Fox Business. When I asked Rep. Sherman why he thinks XRP is a security, he told me for the reasons set forth in the SEC's position, and went on to explain that XRP investors relied on Ripple efforts to bump the price. He then said the proof that he's right stems from the crypto exchanges. So did Rep. Sherman come to see these conclusions? Did the SEC violate court rules and provide Rep. Sherman with a copy of the evidence in this case, which would afford him such knowledge, or is he making these assertions only as recommendations to the SEC chair Gary Gensler on an actual basis? What do you think, guys? We all know that under the rule of law, both parties are bound by the court order not to disclose evidence to third parties such as himself. So, did the SEC provide him with the evidence to prove that XRP is a security, yet refuse to provide the court with the same evidential proof to back their initial allegations? Well, attorney Jeremy Hogan thinks the truth isn't far-fetched from that, and I share the same thoughts as him, but what do I know? Do you think there's a possibility of that in the lawsuit? Let us know your thoughts in the comment section below.
I would like to believe this was probably towards the end of last year. There's a lot of evidence for that. I'm not going to say September. Ripple turned down a settlement from the SEC. They turned it down. They said no. They are so confident. The Ripple team is so confident that they are going to outright win this trial that they turned down an official settlement offer from the SEC. Unless something dramatic happens in the next couple of months, something Ripple couldn't have seen coming, they have their P's and Q's locked so hard. The SEC has looked so terrible. And with every single passing month, the SEC starts getting more and more exposed for the scam, the corruption that they are. Now, I'm going to work on trying to verify this and get more confirmation of this over the next couple of weeks. I'm going to be reaching out to some people that I know, trying to see if we can get some more confirmation of this. But think of the consequences. Think of the reverberations if this is in fact true.
So, what does this latest revelation and contradiction mean for this lawsuit? Well, we all know that the SEC had earlier put a blemish on Ripple, hence impeding the price of XRP. This is why the Ripple team, headed by Brad Garlinghouse, outrightly states that even though the SEC has several times talked about a settlement, Ripple had also refused. on the grounds that only through summary judgment can Ripple rid itself of the stains painted on it by the SEC, as I'm certain the judge thinks so too. The question of whether the lawsuit is about to come to an end is irrefutable and almost conclusive. Given these latest updates, we already know who the victor would be should the lawsuit end this minute. Need I remind you what that would do for the price of XRP? The victory for Ripple would invariably skyrocket XRP to greater heights.
They are losing the case. This is, by the way, Liz, but what are the next steps in this case? I mean, we've been going around and around. It obviously has huge implications. If Ripple wins and they can say they're not a registered security, they're not a security. A crypto.
A crypto.
If they win,
yes, exactly.
that basically is going to curtail the SEC's regulation efforts. And it looks like they're moving in that direction, at least based on the judge's motions. What's the next step here?
Well, the next step right now, there's that Daubert motion, which is just challenging expert witnesses, and briefing next month is due for summary judgments. That's where each side tries to get a complete victory. The judge decides one way or the other, or she might decide that a jury has to issue certain factors. But you're right, Charlie. A lot is at stake because the SEC has come out and argued that the token itself, not just the way Ripple sells it, but that if anyone in the United States sells XRP, they're violating Section 5. So if the SEC were to get its way and deem XRP a security, the token itself, then every altcoin on the market, including Ethereum, would be in play for the SEC to get their hands on this asset.